Good morning. May it please the court. I am Joanne Petito. I'm representing the defendant, Joseph Lee, in this matter. The defendant is appealing from his conviction for breaking and entering with the intent to commit a felony from the Boston Municipal Court, and the defendant challenges the sufficiency of the evidence on that offense, specifically the element of intent to commit a felony. In this case,
now, if you prevail, let's assume that we're persuaded by what you've had to say. Why is the result not simply a reduction of the conviction to the lesser included of a violation of Chapter 266, Section 16A, that is a B&E in the nighttime of a building with the intent to commit a misdemeanor?
the defendant wasn't charged with intent to commit a misdemeanor.
What's the lesser included?
Well, that would depend on the misdemeanor.
Well, it would be A and B.
Excuse me?
It would be assault and battery.
Assault and battery.
Would be the misdemeanor.
The defendant is also arguing that there wasn't sufficient evidence of intent to commit assault and battery, as well as intent to commit assault and battery.
Well, if you break somebody's window and you push your way in the house, what's going to happen when you get in there?
The evidence at trial suggested an attempt to crash the party. The Commonwealth argued...
Well, there's crashing and there's crashing, but if you break a window and push the door open, that's different than just walking in when you're not invited, which I would also consider crashing. But when you crash by physical violence, what do you think is going to happen when you get in there?
Well, it doesn't necessarily support an inference that the prior intents, particularly under a joint venture theory, was to commit assault and battery inside the home.
Now, the appeals courts thus found that the merely forcing the door open essentially meant that the door was being forced against the persons on the other side, and that was sufficient to constitute the assault and battery. Why is that not right?
Well, and that's in the context of assault and battery with intent to commit
right.
a misdemeanor.
I recognize there's a separate question of whether he had knowledge that Mr. McDonough was carrying a firearm, which
a knife,
I mean, which he would need with regard to being armed. But with regard to the A and B with the misdemeanor, why is the appeals court not correct that when somebody is trying to keep a door closed and you're pushing against it to force it open, there's a touching and that's sufficient?
This is something that wasn't developed at trial. It's not something that was relied on. There certainly was no injury in this case. There wasn't any specific testimony that the individual was hit by the door, if I remember correctly.
Counsel, there was argument, there was testimony by Ms. Connor that once the door was, broke the door, shove it in, two people tried to push him out, and they were wrestling each other. There was...
That was after the entry. I believe
quickly that... following upon, right?
Yes.
Shoving entry, and isn't that, and you can consider all that. You think you can't consider all that?
With respect
in the context of the intent to commit an A and B?
I guess that could be considered, yes.
Well, now this
but
was
it would have to... I'm sorry.
This was the third or fourth time these two individuals tried to gain entry to this event?
Yes.
All right, and I take it the Commonwealth's theory, or one of their theories, is that the jury could conclude that they were trying to get revenge or some sort of retribution for being excluded from the party. So they came in with force this time, and one of them had a knife. Why isn't that a theory that would create liability in your client with respect to having a knife? Or
there isn't any evidence that the defendant was aware that his co-defendant had a knife. The knife wasn't used in the home. In fact, it wasn't displayed until after there was they exited from the home and a scuffle ensued outside.
They spent the evening together, these two. They tried to get into this party several different ways. And this time they came in with full force. Why can't the jury conclude that they shared the intent to assault the occupants with the knife that one of them had? They were forced out right away, so they didn't have a chance to pull the knife. But they pulled the knife, or one of them, co-defendant, pulled the knife outside in the yard.
Well, the requirement is that the intent was formed at the time of the breaking and entering and not after entry into the home. Because really was just no evidence that the defendant had any knowledge that his co-defendant had a knife.
Now, help me to understand from the evidence at trial. The door is forced open. They all apparently come in and they roll on the ground. And I gather they're out of there within seconds?
Within less than a minute is the best I can.
And was there evidence as to what the process was by which they managed to be out of the house?
Yes, the testimony was just that they were escorted out. They walked out of the house ahead of some of the party guests. There was no fighting on the way out.
Well, there became fighting very soon. Was it in the front yard where they
It was
started?
outside the front door.
So there was no, when they were inside the house, there's no evidence that there was any punches thrown, anything grabbed?
If I remember correctly, once they were inside the house, the testimony was that the defendant and possibly the co-defendant as well fell on top of one of the party guests, and that they began wrestling with some of the other party guests. And within a minute, they were out of the house.
Actually, the testimony was that the wrestling preceded the falling to the ground.
Now, did Allen or Huddleston testify at trial?
No.
Neither did. So
Neither
this
did.
is just Miss Connor, who of course is on the bottom of the pile.
Ms. Connor testified as to what happened inside the house. She did see some of what went on outside, so she testified to that. There was also testimony by Aaron Murphy, who was outside and testified that the co-defendant pulled out a knife once they were outside the house.
Okay, but I'm referring to what went on inside the house.
It was Miss Connor.
That was Miss Connor, was really the only witness, and of course she was face down on the bottom of
Right.
other bodies.
And she actually testified that she couldn't see what was going on because she was face down on the floor, but when she got up, she saw the backs of the defendants and the backs of her two friends walking out the door.
And once outside, I take it your client had a champagne bottle, which he then proceeded to throw and hit someone with. Where did that champagne bottle come from? Was there any evidence?
There was no evidence as to where it came from. It was not seen. There was no testimony that it was seen before it was in his hand after the incident outside.
But I gather it was an empty bottle based on the evidence.
It seems to be, yes.
There was no suggestion that
right.
it broke and it splattered champagne or anything like that.
That's right.
So there's no indication that he entered the house with that bottle.
That's correct. And there also, and there was no testimony that either defendant was seen with a knife upon entry. The testimony was that he was seen pulling it out, which suggests that it was concealed or at least not visible on the way in.
Now, with regard to the time period that Mr. Lee was with Mr. McDonough, is the evidence simply that they met briefly beforehand? Or I mean, what's the evidence as to how long they were together? Justice Cordy says that both of them tried to get in. Was it only Lee who tried to get in initially, or was it both of them?
Who tried to get into the house at the time that they got in?
No,
they were both,
Earlier.
Earlier.
They were together. From what I recall, the testimony is that they were together. I believe that only the defendant was identified at trial as a person who one of the guests saw on the back deck of the house, and Mr. Murphy, who was the witness, told him, "This is not an open party. You need to leave." There was no testimony as to what happened before the party. There was no evidence as to any planning, any discussions, any statements of these two individuals. A motion for a required finding was filed at the close of the Commonwealth's case, so the evidence that we're looking at is the Commonwealth's case in chief. I did just file a 16L letter citing Commonwealth versus Brown, just to make that clear. There was evidence in the defendant's case that the defendant and co-defendant knew each other from being in the same neighborhood, and also that the co-defendant called for the defendant's assistance outside the house. But in the Commonwealth's case in chief, the evidence was solely that these individuals showed up at the door and attempted to gain entrance to the home. If there are no further questions, I'll rely on my briefs.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, Zach Hillman on behalf of the Commonwealth. Asking this Court to affirm the defendant's conviction for breaking and entering with an intent to commit a felony.
Don't you have to establish that the defendant here was aware that his companion had a knife in his possession?
Not necessarily. I think that the fact finder in this case, who was the trial judge, could infer both that this defendant himself intended to commit an assault and battery with a dangerous weapon once he got inside the house, but also as the way it was argued.
But with what weapon?
Well, my argument would be that the defendant intended to find a weapon once he got inside the house with which to use. And I think the court or the trial judge can infer that given the violent nature of the attack with which the defendant and his co-defendant broke into the house with. Once they were inside
But how is that consistent with what happened when they were inside the house? They just were basically escorted out. There wasn't a big battle.
Well, I would disagree with that characterization. I mean, as soon as the defendant and McDonough get inside the house, they immediately begin wrestling with a couple of the guys inside. That whole pile falls over into one of the other guests, and then immediately thereafter, they're escorted out. So the defendant really didn't have time in the apartment to find a weapon with which to use. Once outside, once he did find a weapon, which was a large champagne bottle, not one of the small ones, a large one, he picked that up and he used it. I think the trial judge could reasonably infer that had the defendant found a weapon inside, he would have used it, and that was his intent when he went inside. I rely on Commonwealth versus Perron, which is a case that I cite in my brief. It's an appeals court case. In that case, the defendant broke into an apartment, and he entered the apartment building empty-handed, but he found a wooden coat rack inside with which he used on the victim inside the apartment to beat him with. The appeals court said, given some prior hostility between the two parties, the appeals court said the jury could have reasonably believed the defendant either intended to use that coat rack or some other weapon inside the house with which to commit the attack.
But there, of course, he did, once inside the house, grab a weapon and use it, and they could infer that that's what he intended to do because he did it. Here, he didn't.
Agreed, Your Honor, but I would say he didn't only because he didn't have the chance to do so once he got inside. It was very quick. Tracy Connor testified that as soon as the pile fell on top of her, she got up, and as soon as she looked around, they were already outside. Aaron Murphy testified to the same exact thing. As soon as the pile gets up, they're already outside.
But the fact that they're outside so quickly suggests that they didn't materially challenge their removal. I mean, I'm not sure what the relative size is. Is there any indication as to the size of Mr. Lee and Mr. McDonough versus Mr. Allen and Mr. Huddleston?
I don't believe that there's any size given for Allen and Huddleston. I believe the defendant was described as generally a big guy. But that brings me to another point, which is the defendant and McDonough knew that there were at least 4 men and 2 women inside this house. I think given the violent nature of the attack, the trial judge could reasonably infer they were going in to commit some violence, some destruction, and that they wouldn't go in kind of empty-handed against greater numbers. I think this court a couple weeks ago just decided Commonwealth versus Housen, and in that case, the court said that you can make a reasonable inference that a defendant going up against a defendant and his co-defendant going up against a person looking to rob a single person of a significant amount of money would not do so unless armed.
Yeah, but this was New Year's Eve?
This was New Year's Eve, Your Honor.
I mean, the context is a little different than robbing somebody. It's New Year's Eve, there's a party. One might infer they want to crash the party, but all these other inferences seem to me to be not, in this context, not grounded in anything.
Well, I don't think it can be characterized as crashing for the sake of going in to ring in the New Year's festivities in this case, given the violence with which they entered. They knew they were not welcome. Nobody knew who these guys were. And they had been told 3 times previously, you guys are not welcome at this party. In fact, at one point, they actually walk into the house. And a couple of the party guests say, this is a private party, you guys aren't welcome. I think the trial judge could reasonably believe, based on that, these guys were angry. They wanted to get some sort of revenge against the party guests, and that form of revenge would take, the form that revenge would take would be an assault and battery with a dangerous weapon. Now, getting back to Justice Cordy's...
So why doesn't the guy go out and get a weapon before he breaks in, knowing that there's 100 people behind the door? There's
12, I think.
or 12. So there's something illogical about that kind of an inference you're asking us to draw, or asking the fact finder to draw.
Well, I disagree. I think the fact finder could reasonably believe that he would go for the first thing that he saw inside. And that also brings me to Justice Cordy's initial question, which was, don't we have to show that the defendant knew that his co-defendant, or wasn't co-defendant because he couldn't be found, McDonough was armed with a knife? And I think the evidence does support that conclusion based on the relationship that the defendant and McDonough had throughout the night. They were together at the beginning when they tried to get in, and at the very end, they're working as a team. As McDonough smashes through the window, the defendant is pushing.
How big is the knife?
I don't know the answer to that. I don't believe the knife was found. But they were working as a team. The defendant pushes the door open against the three people trying to hold him back. Once the fight spills outside, the McDonough is lunging with the knife. The defendant's right next to him, punching, shoving, pushing. Once he finds that dangerous weapon, the champagne bottle, he picks it up, he throws it over the fence, and he hits a girl, causing serious injury. Once they hear the sirens, both of them escape together. I think given all of that evidence, the fact finder could reasonably believe these guys were in a relation. I mean, the relationship between the two would lead to the inference that the defendant knew that McDonough had a knife, especially going up against a larger number of people inside the apartment.
Now, you write on page 21 of your brief, the judge would have been warranted in finding, based on this evidence, that the defendant and Mr. McDonough were intent on committing any number of felonies, including malicious destruction of property over $250, armed robbery, kidnapping, armed assault with intent to murder, mayhem, or even murder. Do you stand by that?
My point is, Your Honor, the Commonwealth tried the case on a theory that these guys went in trying to commit an assault and battery with a dangerous weapon. But the judge didn't have to find just that the defendants intended to commit just that crime. He could have found any number of crimes with which he could infer the defendants intended to commit some felony. And I do think, given the use of the knife here, given the smashing open of the window, given the violence with which they entered the apartment and the violence which ensued afterwards, that the judge here could have found any number of felonies with which the defendant intended to commit once he got inside.
Aren't you asking us to greatly expand the law in this area? I mean, what it boils down to is two people spend some time together, use force to get in, and then basically that's all you need, as long as something down the road happens, even if it's after they leave.
I don't think I'm asking the court to expand the law, because the law is that you can infer the intent to commit a felony from the actual commission of the felony, and the cases are very clear on that. I think just because the felony in this case wasn't committed inside the house doesn't mean they didn't intend to commit it once they got inside.
Then the expansion is also with respect to what the co-venturer has to know. Basically, you're inferring from the fact that it happened that he must have known without anything else, just the fact that there was a knife.
I disagree, Your Honor. I think based on the relationship between the defendant and McDonough, and also the fact that they're going up against, which they know to be a greater number of people inside, given the Commonwealth theory, which was revenge to get inside, I don't think we're asking the court to expand the law in this area at all. I mean, obviously this court has to take it case-by-case basis, the facts based on each case. In this case, I'm simply asking the court to affirm the judge's finding that the defendant intended to commit a felony based on the actions in this case, which were, again, a very violent attack on a group of kids who were just trying to have a nice New Year's Eve party.
All right, thank you, counsel.
Thank you, Your Honors.